Well, being that I'm a Georgia boy, you know what I'm saying, I'm always going to get a hometown, the home team, the home state, the information that I know some people need to know. So this is some information about a person that had a traffic stop, gave a false identification, found all kind of dope on him, and let's see what happened. You're going to be surprised. Court, okay. This is the case SHUMATE versus State 2024, just last year in Georgia. Court of Appeals. Facts. Officers approached SHUMATE's vehicle in what the court found was a first-tier encounter. Voluntary, not yet a stop in the Fourth Amendment sense. During that encounter, officers asked for an ID and SHUMATE gave them a driver's license that did not match his appearance. One officer saw SHUMATE holding a screwdriver and ordered him out of the car. That escalated the encounter to a second-tier detention under Fourth Amendment doctrine. A K-9 was brought in, alerted on the car, and a search revealed methamphetamine and other contraband. After the search, SHUMATE was asked for his real identity. He then gave his true name and date of birth. The legal holding analysis, I'm just getting this from my legal sources, so I'm reading off of my information. So you to be accurate, this is it. Legal holding, this is the analyst of a first-tier encounter and official duties. The court held that even in a first-tier involuntary encounter, officers are engaged in official duties when they ask for identification. Because the encounter was voluntary, SHUMATE could have refused the request or simply ignored it. But he committed a misdemeanor by giving false identification with the intent to mislead under OCGAS 16-10-25. Case law. Escalation to stop a detention. When the screwdriver was spotted and he was ordered out of the car, the court recognized this as a second-tier interaction, detention that requires reasonable, articulable suspicion. It required suspicion. The court found that the officers did not have reasonable, articulable suspicion to detain him initially because of the false ID and other factors, the time of the night, and conflicting statements, officers' safety concerns. But critically, the court said that the officers did not continue investigating the false ID. That's what they fucked up at. Instead, they shifted to a drug investigation before fully resolving the ID issue. Stay with me. Because the detention was justified only by the false ID, a misdemeanor, and they abandoned that line of investigation, the court held the trial court abused its discretion in denying SHUMATE's motion to suppress. The results: the Court of Appeals reversed the denial of the suppression motion, meaning some of the evidence collected during that detention may be suppressed because the stop was improperly prolonged. It was shifted from investigating the ID to let's see what else this motherfucker got. What does this mean for your rights in Georgia? Based on this case and existing laws in Georgia, even in a voluntary encounter, police can ask for your ID, driver's license. That is within their official duties. Refusing to identify yourself in a first-tier voluntary encounter is legally okay in Georgia. According to the court in the state, SHUMATE could have ignored the officer's request. But giving false identification is a crime in Georgia. If the encounter escalates to a detention stop, then the police need reasonable, articulable suspicion to I lost my phone ring. Articulable suspicion to justify it, and that suspicion must actually be about something they investigate. Let me read that again, because if the encounter escalates to a detention stop, then the police need reasonable, articulable suspicion to justify it, and that suspicion must actually be about something they investigate. They can't just latch on to one thing and then ignore it entirely. The court in SHUMATE faulted the officers for abandoning the false ID investigation and switching to a drug investigation without a sufficient new suspicion. So, you got it, Georgia. Hey,